Vigilant Quickie. Boy Scouts of America v. Dale is one that's featured prominently in the discussion about gay rights. This is another First Amendment case, this time about the right to free association. When the Boy Scouts of America excluded Scoutmaster James Dale, who had come out and become an activist for gay rights, Dale filed suit in New Jersey Superior Court, saying this ran afoul of state anti-discrimination laws. The state Supreme Court agreed with Dale and ordered the BSA to readmit him, but they appealed to the U.S. Supreme Court and they reversed. The BSA Scoutmaster policy was that none of them should engage publicly in any discussion of sexual issues. The court ruled 5-4 that the Constitution prohibits the Boy Scouts from being forced to associate themselves with a particular message. Chief Justice William Rehnquist wrote that the law, quote, violates the Boy Scouts' First Amendment right of expressive association. Government actions that unconstitutionally burden that right may take many forms, one of which is intrusion into a group's internal affairs by forcing it to accept a member it does not desire. Such forced membership is unconstitutional if the person's presence affects in a significant way the group's ability to advocate public or private viewpoints. That's the difference. Civil rights are about associations with a group. The First Amendment is about association with a message. And the First Amendment wins out. They relied on a 1974 case, Roberts v. United States J.C.'s. Implicit in the right to engage in activities protected by the First Amendment is a corresponding right to associate with others in pursuit of a wide variety of political, social, economic, educational, religious, and cultural ends. This right is crucial in preventing the majority from imposing its views on groups that would rather express other, perhaps unpopular ideas. And as with all of our other rights, freedom of association plainly presupposes a freedom not to associate. Whereas it's not really discrimination, since they weren't excluding all homosexuals or all scoutmasters who merely disagreed with the policy. Quote, the presence of an avowed homosexual and gay rights activist in an assistant scoutmaster's uniform sends a distinctly different message from the presence of a heterosexual assistant scoutmaster who is on record as disagreeing with Boy Scouts policy. The Boy Scouts has a First Amendment right to choose to send one message but not the other. If you're wondering how the dissent by John Paul Stevens resolved this constitutional issue, well, it didn't. Quote, that such prejudices are still prevalent and that they have caused serious and tangible harm to countless members of the class New Jersey seeks to protect are established matters of fact that neither the Boy Scouts nor the court disputes. That harm can only be aggravated by the creation of a constitutional shield for a policy that is itself the product of a habitual way of thinking about strangers. As Justice Brandeis so wisely advised, we must be ever on our guard, lest we erect our prejudices into legal principles. If we would guide by the light of reason, we must let our minds be bold. Yeah, he pounded the table. Private groups are not the state. Private groups and individuals have rights which the state cannot for any reason infringe, whereas the state must treat everyone impartially, regardless of how it feels about how bad their opinion is. That's for the marketplace of ideas, not the government.